Uh, Good afternoon, ladies and gentlemen. It's my great pleasure to welcome you all to this event, this public lecture, which is one of the lectures which we are organizing this academic year to celebrate the 55th anniversary of our Faculty of Law. As many of you know, legal education at Hong Kong U began in the year 1969 when the law department or law school was first established. Today, the lecture is entitled the Eric Au Memorial Lecture. The late Eric Au was also one of the early graduates of our law school, and he was a pioneer in the development of bilingual legislation in Hong Kong. This memorial lecture series were established to commemorate him and to promote knowledge and understanding of legal bilingualism and law drafting. We are today extremely honored that Madam Justice Carlye Chu, the Vice President of the Court of Appeal of Hong Kong, will be giving this Eric Au Memorial Lecture. I will first invite the Dean, Professor Fu Ha-ling, to introduce Madam Justice Chu.
Thank you. Thank you very much. Good afternoon, ladies and gentlemen. Welcome to the Faculty of Law, the University of Hong Kong, and to the Eric Au lecture today. Legal bilingualism, reality and the destiny of Hong Kong is a topic of utmost importance and relevance to us. Well, we often look to Canada and its Montreal model of a bilingual legal education as an example. Today, this lecture offers a unique perspective. The Honourable Madam Justice Chu will transport us to medieval and earlier modern Europe, exploring the possibility of bilingualism in a different context. This journey through time promised to be a thought-provoking one, bringing us back to the future of legal bilingualism. The Honourable Madam Justice Chu is no stranger to the law school. She obtained both her LLB and PCLL from this law school. Subsequently, she received her LLM from LSE and a master's in social sciences in criminology at Hong Kong U again. She's currently vice president of the Hong Kong Court of Appeal. Before her appointment to the bench, she was a barrister in private practice. Let's welcome the Honourable Madam Justice to deliver the 2024 Eric Au lecture on legal bilingualism in medieval Europe and Hong Kong.
Thank you, Professor and Dean Wu, for the very kind and generous introduction. Dean Wu, Professor Chen, friends, distinguished guests, ladies and gentlemen. It is both an honor and pleasure to speak on this lecture series in memory of the late Mr. Eric Au Wai, not least because of the very insightful lectures delivered by learned speakers in the past, and the fact that Eric and I, and indeed Albert too, had crossed paths during our time in this law school. Eric was in his PCLL year. Albert should be in his final LLB year, and I was a first-year fresh in this law school. But my connection with Eric, in fact, predated that. It may be less known that Eric had a passion for and was very well versed in the German language. He and my elder sister were classmates in the Goethe Institute of Hong Kong, and I had the benefit of his advice when deciding on my choice of university study. Eric had a distinguished record of serving this community, including being a member of the Basic Law Consultative Committee and the Assistant Director of the Hong Kong Red Cross. But he is best remembered, as Albert mentioned, as a pioneer in legal bilingualism in Hong Kong. Before his unexpected passing in 1992, at the very young age of 39, he was the deputy law draftsman, taking charge of the daunting and historic task of preparing the Chinese texts of the legislations previously enacted in English. The then Attorney General, Mr. Jeremy Matthews, when announcing his passing, had described his immense contribution to the implementation of the bilingual law drafting program as this. Mr. Au was firmly committed to the completion of the bilingual law drafting program and believed profoundly in the usefulness of the program to the community. That Eric has sowed the seeds and set the path for a bilingual legal system in Hong Kong is without doubt. It is therefore befitting for me to speak about legal bilingualism on this occasion. But I must disclaim any originality for the idea of this talk. The idea was inspired by Mr. Zhang Zizin, an outstanding graduate of this law school, who is now a practicing barrister, as well as, I think, a part-time lecturer too in this department of law. I have derived much assistance from his deep interest and knowledge in Roman law, and I'm very grateful for his generous sharing of his knowledge. As the old Chinese saying goes, 借古鑑今, it is often instructive when envisioning the future to look to the past for enlightenment. In this lecture, I propose to reflect upon how the medieval experience of the adoption of Roman law in Europe may inform the development of the bilingual common law system in Hong Kong. And I intend to begin with a brief account of the adoption of Roman law in medieval and early modern Europe, followed by a review of the adoption of the common law in Hong Kong and the bilingual legalism development, before coming to a discussion of the theme. Now, in the world today, there are two great legal systems of European origin, the civil law and the common law. The former has its root in the Roman law and is practiced in most of the countries in Europe, including France, Italy, Germany, and the Netherlands. The latter comes from the common law of England and is adopted in the majority of the English-speaking world, such as the United Kingdom, Australia, New Zealand, Canada, and Singapore. At a very high level of generality, it can be said that Roman law has lived two lives. In its first life, it was the law of the ancient Romans, that is the city of Rome and the Roman Empire. This was in the period from the founding of Rome in the 8th century before Christ to the fall of the Western Roman Empire in the 5th century AD. A picture of this first life is to be found in a collection of laws and juris writings known as the Corpus Juris Civilis, in English, the body of civil law, compiled by the order of Emperor Justinian in the 6th century AD. With the fall of Rome, Roman law fell into relative obscurity. The Roman law made a second claim some 6 centuries later in the 11th century. It began with the rediscovery of, in Italy, of the digest, which is the most important part of Justinian's Corpus Juris, and the revival of the teaching and study of Roman law in the universities of northern Italy, notably the University of Bologna, which later spread to universities in southern Italy, France, and beyond. In addition to the establishment of law as a scholarly and scientific discipline taught in universities, the revival Roman law has sparked off a process of reception and adoption of Roman law in cities, kingdoms, and nations across Europe over the course of the Middle Ages and modern and early modern period. In its second life, Roman law has shaped the legal systems that ruled most of Western Europe, and these legal systems that descended from Roman law have come to what we now know as the civil law systems. Perhaps at first glance, it may seem odd that medieval Europeans would choose to adopt laws developed for ancient Rome. Scholars have offered a number of reasons for this historical development. One commonly held belief was the authority of the Roman Empire. Although the Roman Empire had long been defeated, it continued to exercise a degree of authority and influence in man's imagination. And that is why Charlemagne was crowned Emperor of the Romans, the first of the so-called Holy Roman Emperors. In line with this myth, Roman law had a claim to universal authority, making it an ideal candidate for forming the basis of the common law of Europe. The status of Latin in the Middle Ages as the lingua franca of the educated elite also contributed to its suitability for the role. But there was another important practical reason for the adoption of Roman law. After a period of decline due to the loss of security and stability in the aftermath of the fall of the Roman Empire, trade and commerce began to grow in the 11th to 13th centuries, notably in Italian cities such as Venice. The existing laws of the Middle Ages were, however, inadequate to deal with the increasingly complex commercial issues. And Roman law, on the other hand, was an excellent model to meet the demand. In the first place, the Romans were themselves active traders engaging in a high volume of trade. As a result, Roman law was well equipped to deal with commercial issues, boasting a vast literature on contract law, especially the law of sale. More importantly, the detailed rules of Roman law were developed by professional jurists who discussed numerous real-life and hypothetical cases, culminating in the development of highly sophisticated concepts and principles. The digest in Justinian's Corpus Juris, which contained detailed and comprehensive private law, provided a body of contract law that was well suited to facilitate commercial dealings and address practical issues and disputes. Studies on the GDP per capita estimates since the first year AD show that during the Middle Ages, the per capita economic levels of most parts of Western Europe were well above other world regions. Scholars have attributed the economic rise in medieval Europe to the adoption of Roman law and the scientific, rational, systematic, and more individualistic approach of legal scholarship that accompanied the process. In sum, Europe was enriched by the rediscovery and adoption of Roman law. The concepts, principles, and juristic debates of Roman law provided a highly fertile basis for the jurists of the Middle Ages and early modern period to develop a shared jurisprudence for Europe. The resulting civil law tradition is today the most widespread system of law in the world. Perhaps the significance of Roman law is best exemplified by the fact that to this day, the study of Roman law remains a compulsory subject of the undergraduate courses at Oxford and Cambridge. The adoption of Roman law into the legal culture of medieval Europe was not a wholesale, indiscriminate process. Rather, it was a dynamic process. Jurists throughout the centuries wrote commentaries debating the writings of Roman jurists and commentaries on those commentaries. Roman law was adapted, rationalized, and transformed, so that the civil law today is in fact vastly different from the Roman law of antiquity. The true strength of the civil law lies not in strict adherence to the original meaning of Roman law, but in the ongoing attempts to apply the resources of Roman law to the evolving needs of medieval society. One significant aspect of this transformation was linguistic. Roman law was written in Latin. By the time of the revival in the 11th century, Latin remained a language of the educated elite, but it was no longer the ordinary language of the people who spoke either Romance or Germanic languages. Over the centuries, the gap between the language of the law and the vernacular language of ordinary people was closed by gradual translation and adoption of the principles of Roman law into the vernacular languages. Nowadays, only a minimal amount of Latin terms remains in the civil law. A recent study has considered this development in the context of Northern France. In Northern France, prior to the 13th century, the vernacular was generally the spoken language of legal practice in the courts, whereas Latin was the language of record, written law, and communication between educated elites, the language of universities, and erudition. Although the French recognized the value of the new learning about Roman law in Bologna, such learning was not accessible to most of those engaged in legal practice, not to say the general population. The vast majority of those who ran the secular courts of Northern France participated in trials there or watched them spoke only their own vernacular. They did not understand written language, let alone Latin, either spoken or written. So this was the description given of the situation at the time. French lawyers went about bridging this gap by translating Roman law texts from Latin into French. They started with Justinian's Institutes, which was an introductory textbook of Roman law. The translation took place sometime between 1220 and 1230, approximately the same time, or perhaps even earlier than the first French translation of the Bible. By the end of the 13th century, the entirety of the Corpus Juris Civilis, including the digest, which comprised 50 books of jurist writings, had been translated into French. Other texts that were translated included works of canon law and important medieval commentaries. The translation process carried a number of significance and consequences. The translation of Roman law had influenced the enactment of statutes in the French language and the writing of textbooks in French, on French customary law, broadened the influence of the Roman learning and making it more accessible to the ordinary people. Although also through the linguistic choices made in the course of translation, French lawyers had transformed the original text and in a way domesticated Latin concepts and adapted them to the local context. In one example, a translator of Justinian Institutes chose to translate a text into verse form for the purpose of preparing students for their study of the same text in Latin. It would appear that many French students for whom Latin was not their native language struggled to master the complex legal concepts in Latin. So learning the textbook first in French rhyming couplets would have made it easier for them to learn and understand it in Latin later. So much about the medieval past. We now turn to the present, the common law system in Hong Kong. The common law system is the second most prevalent legal system in the world. The reason for its adoption in Hong Kong is historical. When Hong Kong came under British rule in 1843, the Supreme Court ordinance provided that the laws of England, that is the English common law, shall be applied to Hong Kong. This position has been entrenched by the Basic Law through Article 8, which provides that the laws previously in force in Hong Kong, which included the common law, shall be maintained. As recent as 2022, on the occasion to mark the 25th anniversary of the establishment of the Hong Kong SAR, Presidency had reaffirmed the need for Hong Kong to maintain its distinctive status and edges, including to maintain the common law so as to expand and facilitate its changes with the world. One of the fundamental features of common law system is a system of case-based reasoning. Unlike the modern civil law, that is, the civil law post the codifications in the 19th century, the common law does not seek to distill and codify all legal principles into general theoretical propositions. Rather, the common law is a continuous and never-ending discussion about how to achieve fairness in actual cases in the light of competing values. Our former Chief Justice Geoffrey Ma has instructively described extrajudicially this characteristic of the common law approach in this way. The whole methodology and approach of common law courts is designed to provide guidance to the commercial community, and one might add, the general population, by dealing with real-life situations, often in specialized trades, and their many nuances. It is a recognition that all principles of law must be and can only be developed through real experiences and not just theoretical ones. Alongside the values of practicality, openness, and versatility, the common law holds as equally fundamental the values of fairness, certainty, and adherence to consistent principles. The two sets of values are held together by the doctrine of precedence. As our former Chief Justice Andrew Lee observed in Solicitor and Law Society of Hong Kong in 2008, which is the leading authority in Hong Kong on the doctrine of precedence. The doctrine of precedent is a fundamental feature of our legal system based on the common law. It gives the necessary degree of certainty to the law and provides reasonable predictability and consistency to its application. Such certainty, predictability, and consistency provide the foundation for the conduct of activities and the conclusion of business and commercial transactions. But at the same time, a rigid and inflexible adherence by this court to the previous precedents of Privy Council decisions on appeal from Hong Kong and its own decisions may unduly inhibit the proper development of the law and may cause injustice in individual cases. The great strength of the common law lies in its capacity to develop to meet the changing needs and circumstances of the society in which it functions. So the common law that contains within itself the means for adapting to different and changing circumstances on a gradual and principled approach. In the words of our Court of Final Appeal in the case of Canceland Realty Limited and Tai Tang and Chong, decided in 2008. Judges developed the common law against a background of the social, moral, economic, and political values and assumptions of the societies in which they work. And the values and assumptions of societies are not necessarily the same. The common law recognizes and embraces this diversity, as is reflected in the variety of legal principles developed in common law systems across the world. The common law system now practiced in Hong Kong is, of course, a unique one. It is one of the few bilingual common law systems and the only English and Chinese bilingual common law system. This was not always the case. For most of Hong Kong's history under the British rule, the common law system was monolingual with English as the only language of the law. Although the Official Languages Ordinance, Cap 5, was enacted in February 1974, making both English and Chinese the official languages of Hong Kong, the prospect of a bilingual common law system did not emerge until 1986, when the Hong Kong Royal Instructions were amended to provide that laws shall be enacted in English and Chinese. This was followed by the amendment of Section 4 and the addition of Section 4A to the Official Languages Ordinance in 1987. The former mandates the enactment of ordinances in both official languages, while the latter enables the making of subsidiary legislations in both official languages. Another important milestone in legal bilingualism in Hong Kong is the amendment of Sections 3 and 5 of the Official Languages Ordinance in 1995, which recognizes Chinese as an official language for court proceedings and further permits both Chinese and English to be used in court proceedings. After the signing of the Sino-British Joint Declaration in 1984, the then legal department embarked on an extensive program to translate all existing statutes into Chinese, in addition to enacting new bilingual legislations. In 1986, the department's bilingual section was established with two teams being formed. The first is what is called the existing law team, which its task was to translate the over 500 existing ordinances into Chinese. And the second team, called the current law team, was tasked with drafting new laws in both languages. Eric Au was among the pioneers and headed the existing law team. The first bilingual ordinance was the Securities and Futures Ordinance, Cap 571, enacted in 1989. With the making of various subsidiary legislations and legislative amendments, the use of Chinese in conducting court proceedings was phased into all levels of court. By the time of the resumption of sovereignty in 1997, Hong Kong's legal system was fully bilingual. Legal bilingualism is entrenched by the Basic Law under Article 9, which provides that, in addition to the Chinese language, English may also be used as an official language by, among others, the judiciary of the Hong Kong Special Administrative Region. Now that we have looked at the past and the present, what parallel and lessons can we draw? First, I would say bilingualism is an asset. Were it not for the bilingualism of medieval society, the medieval Europeans would not have been able to draw from the wealth of learning and knowledge contained in Roman law. The opportunities for cross-fertilization of knowledge across Europe will also have been much more limited. The civil law today is the product of the shared jurisprudence of Italian, French, Spanish, Dutch, and German jurists and others, with Roman law as the foundation. None of this would have been possible without an openness to bilingualism and multilingualism. Conversely, Roman law would not have developed into the successful civil law tradition of today were it not for the medieval jurists' creative attempts to adapt Roman law to their own cultures, languages, and societies. In the case of Hong Kong, that bilingualism is a valuable asset and a distinctive advantage has long been recognized. Our education policy, for instance, have for a very long time promoted 2 written languages and 3 spoken languages, 兩文三語. In the realm of legal bilingualism, I venture to say that this is both valuable and necessary. Just as medieval Europe was enriched by the revival and reception of Roman law and its sophisticated common law, commercial law, Hong Kong has also benefited greatly from the adoption of English common law. We have earlier on seen that Roman law had a significant influence on medieval economic growth. Likewise, the common law system has a decisive impact on Hong Kong's economic success. The commercial values enshrined in the common law, the rational and practical method of common law reasoning, and the doctrine of stare decisis, together with the values it underscores, all contribute directly to Hong Kong's status as an international commercial and financial center. Maintaining internationalism and a spirit of openness is critical to the continuing growth and development of our law. English is the language of the common law and the primary language of common law systems across the world. As the former Chief Justice Andrew Lee once observed, the tradition of the common law has its roots in English, and its literature is mostly in English. if Hong Kong is to participate in the continued development of common law jurisprudence and expand and facilitate its exchanges with the world, it must continue to engage with the English language tradition of the common law. At the same time, the integration of Chinese into Hong Kong's common law tradition is essential for the legal system to take hold and thrive. It ensures that the law is accessible and intelligible to the general public, which is a basic requirement of the rule of law and something vitally important to cultivating an understanding of the common law and an appreciation of its core values among the general public. The lifeblood of the law is its reflective response to the living experience and needs of the population. This is true of any workable system of law, but is particularly true of the common law. The integration of Chinese into our common law system is therefore crucial. And this brings me to the second point about bridging the gap between the language of the law and the vernacular language of the general public. The challenge for Hong Kong in this regard cannot be understated, because no other jurisdiction has the experience in the use of Chinese in a common law setting to help us. The vast majority of existing resources that we have are in English. In addition, law is a technical subject replete with abstract concepts and technical jargon. And for much of this jargon, there is an absence of exact or opposite equivalent in the Chinese language. And as a character-based language in which new characters are rarely, if not almost never, invented, the inventory of the Chinese language for dealing with quote-unquote foreign concepts is more limited and less flexible than that of an alphabetical language in which borrowed words are more readily and constantly created. So we should not expect this to be an easy process. Much has already been done, but much more needs to be done. If I may, I would just offer one potential way in which we might learn from the efforts of the medieval lawyers. And this is in terms of translation of common law books into Chinese and the writing of law books in Chinese. There are currently just a small handful of books in Chinese on the common law. One very early effort was an edited volume called 香港法律18講, published in 1987, to which many people had contributed, including lawyers and academia. The late Professor Betty Ho published a book on contract law in 1995, and in 1999, there was an edited volume, 香港法概論, which was published under the co-editorship of Professor Albert Chan, Professor Johannes Chan, Professor Alice Lee, and many others. It is now in its third edition. There were also recent efforts by Dr. Anthony Lo of the Chinese University of Hong Kong. He had published books on contract law, tort, and constitutional rights. There are also legal dictionaries, notably the Hong Kong English Chinese Legal Dictionary, edited by a team of judges, lawyers, and academia, led by Mr. Justice Patrick Chan, the non-permanent judge of our Court of Final Appeal. But these and others like it are, of course, all valuable and important efforts. But generally speaking, high quality, serious, and accurate books on the common law in Chinese, whether original or translated, would seem to me to be exception rather than the norm. This is so notwithstanding the availability in Hong Kong of a pool of talented legal practitioners and scholars who possess expertise and ability to author books on the common law. And there are many who have the language skills to assist in the endeavors. The medieval experience has shown that the writing of legal literature in the vernacular is very much a pivotal part of the transmission of knowledge. One striking illustration relates to how the learning developed in the civil law in the Middle Ages and early modern period was eventually received into the common law. Many private law concepts we nowadays take for granted are no older than the 19th century. Just to take a few examples from contract law, the doctrine of offer and acceptance dates back to Adams and Lindsay in 1818. The doctrine of intention to create legal relations dates back to Carlye and carbolic smoke, decided in 1893, and the doctrine of remoteness goes back to Adley and Baxendale in 1854. Many of these concepts were not native to the common law. The common law had for a long time structured its legal system around forms of action rather than substantive legal principles. These principles were in fact borrowed from civil law. This was enabled by translation of writers in the civilian tradition into English editions in the 18th and early 19th centuries. It has been said that the English treatise writers of the 19th century, to a greater or less extent, married their knowledge of the common law to their knowledge of these civilian writers and to Roman sources. In other words, without legal translation and without the English writers and the judges' openness to foreign influences, we will not have the rich body of English contract law as we know it today. Here in Hong Kong, there are three specific audiences who may benefit from legal translation. The first would be law students. You will recall the example of a French jurist who translated a medieval French law book into verse form in the French language. No doubt this writer understood that for students to whom Latin was a foreign language, the language barrier would cause obstacles to learning and understanding. And I suspect some of our law students may feel likewise in their endeavor to master the common law. But I have to make it very clear, I'm not here advocating that Chinese law books can ever or should be a substitute for English law books, let alone a substitute for reading English law reports. Rather, I think Chinese law books could solidify their understanding of legal concepts and in turn enhance their ability to apply the law to suit local circumstances and the changing demands of the day-to-day situations. The emphasis is on training up the bilingual ability of our law students and the building up of a more diverse and accessible legal profession. The second group who may benefit from law books in Chinese would of course be the legal profession. Nowadays, use of Chinese in legal documentation and in court proceedings are increasingly common. The demand to accurately articulate legal concepts to lay clients and make legal submissions to the court is ever on the rise. While English-Chinese legal glossaries and dictionaries offer it useful working tools for practitioners, they do not convey a holistic impression of the legal principles involved, nor do they reflect how the principles may be applied to specific and different contexts. In this regard, Chinese law books would provide a more detailed and in-depth, useful legal discourse. The third group who may benefit from law books in Chinese on common law is the legal practitioners and perhaps also the public in mainland China and other Chinese-speaking territories. The historical examples that we have previously discussed show the great potential for cross-fertilization across different legal systems. Bridging the language gap will be an important step towards fostering deeper mutual understanding of the Hong Kong and mainland Chinese legal system. That is the two legal systems operating within one country and their respective core values. This kind of project carries public value, but is neither easy nor particularly attractive or marketable. Textbooks on local law take a long time to write and are likely to be published in very prestigious publications or to gain a high citation count. There is understandably little personal incentive for busy practitioners, academia, or judges to take time out to embark upon such substantial profits, notwithstanding the recognition of the value. But if I may say this, these are projects that are worth the while and worthy of support of our legal community. I wish to close this lecture by these thoughts. The adoption of a legal system is not just about transplanting or implanting the letters of the law or the taking of legal principles. It requires the simultaneous acceptance of the intrinsic values that underline and vitalize the system of law. It would seem to me that the sustainability and the future of Hong Kong's bilingual common law system lies in, firstly, the accessibility of the law to the general population. Secondly, the maintenance of Hong Kong's connectivity to the international common law community. And thirdly, the preservation of the intrinsic values of the common law and the common law system. So with these thoughts, I conclude the lecture today. I thank you for your time and your attention.